Give me a minute. I'm trying to get this going on Zoom. I mean, on YouTube. All right. In the weekly or sometimes multiple times a week category of Zoom doing stuff it's never done before, I sign into Zoom this morning and it says I have no meeting scheduled for today. I go to my calendar because I'd gotten the reminder at 8:30 and it says, yes, I have a meeting and I'm the host. So I launch it through I try to join it through my calendar and then it asks me, do you want to launch? But okay, I'm going to call the civil dockets. If you're here for a criminal docket, it's unfortunate because you're supposed to be in Karn City in person in front of Judge Ellison. As for announcements from the attorneys, if you don't have an attorney or your attorney's not here, make sure I know that you're here present. In the interest of Serenity and Trinity Farias.
I'm here, sir.
All right, and what do we have to hear today?
A motion to
Motion of enforcement. His girl's mother took the kids and she hasn't returned them since August. They've missed the entire year of school because of it, and he has legal custody.
Okay, ma'am. All right. What's the mother's name?
Gabriella Rodriguez.
All right, is she present?
unfortunately, sir, we don't know if she's been served or not. We tried serving her through 17 addresses and we haven't had a response yet.
This will be the third time.
All right, ma'am, I need to tell you, you're not a witness and you're not an attorney, I believe. Is that correct?
Yes, sir.
And you're not a litigant, so we need to let Mr. Farias speak. I'm going to mark you A, sir. You'll be the first self-represented case that I call up.
Yes, sir.
Maria Parras versus Cnty Investment.
That case has been dropped, Judge.
All right. Matter of the marriage of Arenas.
Your Honor, Michael J. Knight for the petitioner, 5-minute uncontested prove-up, Your Honor.
Carlos Arenas, sir. I'm here, sir.
All right, sir. I'll mark you number 1. The state of Eugene Dorotzik versus Deborah Liska et al.
Judge, that case has been dropped and reset on request.
KD Allen Investments versus certain underwriters subscribing to policy number TX something or another.
Your Honor, Justin Ratley and Julie McClintock are here on behalf of KD Allen.
Avniel Adler here on behalf of underwriters, Your Honor.
All right, and what do we have to hear?
There's 2 motions before the court, Your Honor. The plaintiffs have got special exceptions against 2 of underwriters' affirmative defenses, and then underwriters has a motion for entry onto property.
Okay, and I'm sorry, that's Mr. Adler, you announced on the other side?
Yes, Your Honor.
All right. How long to hear this?
We have two motions, so I assume 5-10 minutes each.
Okay, all right. It's a short docket, but I'll mark you 20 minutes. Okay. Karn City versus Freeport McMoran and versus Elite Compression.
Good morning, Your Honor. Jeff Garcia on behalf of the plaintiff, Karn City ISD. We announced ready on this default judgment.
On
Good
both?
morning, Your Honor. John Banks, on behalf of the interveners, we're also ready.
Okay. All right, and these are newer cases, so these are not the old cases that were about rentals that got abated. Okay, I'll mark the tax cases together. Matter of the marriage of Jessica and David Segura.
Yes, sir, I'm here.
Yes, sir, I'm here.
Okay, and what do we have to hear this morning?
I'm sorry, for a divorce?
Okay, is it for divorce or for protective order?
No, we have a current protective order. It's actually for a divorce.
Okay, and you're both ready to proceed.
Yes.
sir.
All right, Mr. Segura, if you will remove your hat while you're in court, I will mark you B. You'll be the second self-represented case I call up. State of Texas versus $1,093 in US currency.
William Richmond for the state. It's a motion for default judgment and should take less than 5 minutes.
Okay, I'll mark you 2, I think. Anybody else told to be here today, your case was not called? All right, give me a chance to hopefully get into Odyssey and the Karn's district clerk's documents. All right, the matter of the marriage of Arenas.
Ready, Your Honor?
All right,
May I have my witness sworn?
yes, may I ask both the husband and wife to, if you'll raise your right hands. And sir, if you'll unmute your computer too.
Was that us, sir?
No, that's on the Arenas case. Do both of you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, sir.
All right. Go ahead, sir.
May it please the court. Ma'am, please state your name and address for the record.
Brandy Arenas, 646 County Road, 160, Cnty, Texas, 78119.
All right, and Ms. Arenas, were you a resident of Karnes County for 6 months and also for 90 days prior to the filing of this divorce action?
Yes,
Were you married to your husband on or about July 13th, 2002, and ceased to live together as husband and wife on or about July 22nd, 2018?
yes,
Has the marriage become broken and without any reasonable expectation of reconciliation?
yes.
And there was one child born to the marriage, is that correct?
There's been 2. One has passed away.
That
5
is
years ago.
correct. My apologies. However, are you expecting any children at this time? All right. I'm showing you a document which is entitled Agreed Final Decree of Divorce and Order for Conservatorship and Child Support. And I direct your attention to the last page. Is this in fact your signature?
Yes,
Is that also your husband's signature?
yes,
And does this document contain all the agreements you've reached regarding child conservatorship, child support, division of debt, and division of property?
yes,
Do you believe these agreements that you reached with your husband to be in the best interest of your child?
yes,
And you believe this is a fair and reasonable settlement of your property and debt issues?
yes,
Are you asking the court to adopt the agreements that you reached with your husband and grant this divorce?
yes.
And are you requesting a name change?
No,
That's all we have, Your Honor.
All right, Mr. Sands, Arenas, doing translation here. You'll have an opportunity to testify in just a moment, but do you?
I will call him, Your Honor, briefly.
Sure, but do you have any questions for your wife at this time?
No, sir. We've agreed on the document, sir.
All right, go ahead, sir.
Mr. Arenas, if I asked you the same questions that I asked your wife, would your answers be any different?
No, sir. I agree.
All right, sir. Thank you so much.
All right, is there anything else either side wants me to know?
Nothing further, Your Honor, for petitioner.
Nothing
Alright,
further, Your Honor.
And do you have an electronic copy of the divorce decree?
Yes, Your Honor, it's all on file in the clerk's file.
Okay. Is that in
Judge, I
the,
have it in, Judge, good morning. I do have those documents in e-file and they are also in Odyssey. How would you want me to get those to you?
if you could just post a copy in chat, that would be the quickest way.
Okay, I can do that.
You just download it from Odyssey?
Yeah.
All right, I find I have jurisdiction to hear this matter. The case has been on file more than 60 days. The respondent has appeared in open court and announced that he's both ready and that he agrees to the entry of the divorce decree. The petitioner had been a resident of Karnes County for 90 days in Texas for 6 months. The marriage between the parties has become undermined due to a discord or conflict of personalities. There's no present likelihood of reconciliation. There's one child born during the marriage who has not reached 18 years of age, and I'll find the orders concerning that child were in the child's best interest, and I will approve them. And I will also find that the proposed division of the marital property and debts is just, fair, and equitable. I will approve the division of them in the divorce decree and pronounce the divorce in open court. Any relief that's not in the decree is denied, so this is a final appealable order. All right, I wish y'all good luck.
Nothing further, Your Honor. Wish to be excused.
Yes, sir.
Thank you, Your Honor.
All right. Mr. Richmond, I have pulled up your case while they were putting on their evidence. I see you got the green card back on the respondent. Go ahead.
All right, first off, I'd ask the court to take judicial notice of the court's file.
I will do that.
All right, this is an asset forfeiture case. The particulars of the seizure are described in Exhibit A. This case was filed on April 19th, 2021. The respondent, Kenya San Juan Warfield, was served by certified mail restricted delivery on April 26, 2021. And the citation and proof of service have been on file with the clerk for 10 days, excluding the day of filing and today. And
actually, Mr. Richmond, I just realized I didn't see how long this, when was the document signed for? The citation and petition?
It was April 26th, Your Honor.
Okay, so the 18th would have been the Monday next, so we're good. All right, go ahead.
Yes, Your Honor. All right, so in that time, the respondent has failed to answer within the time required by law, and therefore has wholly defaulted. State's Exhibit B is a certificate of last known address for the respondent. State's Exhibit C is a non-military affidavit. After doing its due diligence, the state is of the opinion that Kenya Warfield was not, at the time of this filing, a member of the United States Armed Forces, nor at the time this motion was filed was a member of the Armed Forces. So at this time, the state would move for Exhibits A, B, and C into evidence.
All right, and I didn't see that those were filed. Were those filed with the clerk's office?
Yes, Your Honor, those were filed with the motion for default judgment.
All right. Okay, has that been posted in Odyssey? Because I did not see that in Odyssey.
Your Honor, I submitted those. I e-filed those on Tuesday.
Okay. All right. Do you have access to a PDF at your desktop, or are you on your computer?
Yes, I'm on my computer, Your Honor. Do you want me to post those in chat?
If you could, please. All right. Without objection, I will admit the exhibits and take judicial notice of the contents of the file. And I will find that the answer date is passed and grant the relief prayed for.
Thank-
Now, I'll sign your judgment too, if you'll post that in chat, and then I'll just send everything to the clerk's office in one package.
All right, so those should both be in chat now.
All right, let me go back here and look. Yes, they're here. All right, give me a moment. I'm having trouble here. Okay, and I've just posted a copy to the clerk's office and to Mr. Richmond.
All right, thank you, Judge. May I be excused?
Absolutely.
All right, have a good day.
Yes, sir. Give me a moment on the tax cases.
Your Honor, Jeff Garcia here.
Yes, sir.
We're actually going to pass on the second tax case on the elite compression services, if we may. The General Counsel, Mr. Michael Fertitta, on that has sent us confirmation of payment in full. So we'll more likely be non-suiting our calls on that. And I can also provide that information to Mr. Banks as far as getting payment.
Okay, and I mean, companies run on hard times and go out of business, but is Freeport McMahon, are they having troubles? Have they gone broke? Because I mean, they used to be a big company. It just not the fly-by-night outfit that would usually default, or is that no longer?
Correct. And we've personally served them via their registered agent.
Right.
And the situs that we're dealing with on these tax cases are actually 3 mobile homes that they had back in 2015 through 18. So
Okay.
they may have, even though they're still a viable company, like you state, Your Honor, they may have sold those mobile homes not knowing that, they needed to pay taxes to our client, the school district, as there's
Okay.
separate tax offices in Karnes County. So that may be.
They've got their own big trucks. They can haul them to somewhere else without getting a
Correct.
certificate. Okay. All right, that's fine then. Go ahead, sir.
So at this time, Your Honor, plaintiffs asked the court to take judicial notice in the cause number 2010-19 Karn City ISD versus Freeport McMoran Oil and Gas LLC.
Yes, sir. I'll take judicial notice of the contents of the file, including that there's a return of citation in the proper format. It's been on more than 10 days, on file more than 10 days, and their answer date has passed.
Thank you, Your Honor. At this time, plaintiffs Karn City ISD would like to offer into evidence, which has been previously marked as Plaintiff's Exhibit A, certified tax statements from Karn City ISD showing the total amount of taxes, penalties, and interest due to our client in the amount of $4,927.27. And we ask that exhibit be admitted into evidence.
No objection, Your Honor.
Without objection, those are admitted into evidence.
And
Intervener would offer its statement also, Your Honor.
Without objection, that's admitted into evidence.
At this time, Your Honor, I respectfully ask the court to approve of a default judgment in favor of plaintiff and intervener for all the delinquent taxes, penalties, and interest and court costs.
Intervener joins in the request, Your Honor.
Okay. All right, and I will grant all the relief prayed for. Do you have your proposed judgment?
Yes, I think we're waiting on Mr. Banks to get the signature on our judgment, and we will be e-filing that as soon as we get it.
Okay.
And we'll make certain we get that today. And I think we've already e-filed our statement, Your Honor.
Okay. All right, that sounds good. I will sign those whenever they're in the e-file system.
Thank you, Your Honor. Will we be excused?
Yes.
Thank you.
Thank you, Your Honor.
All right, give me a moment on the Farias case. All right, Mr. Farias, if you'll unmute.
Yes, sir.
Okay, sir.
Did I do that right?
Yes, you're unmuted.
Oh, okay.
What I need to ask you is, have you even attempted to get this served on the mother of the children?
Yes, sir. We've done it about 2 or 3 times with no success.
Because I don't even see on the district clerk's records where a citation was issued. I see there was a motion for enforcement was filed on November the 18th of last year. And then you signed an affidavit of some sort on March the 8th of this year. And then there was a notice of hearing.
Yes,
but the citation is a formal order that's signed by the clerk that says, hey, you're being sued. Here's a copy of the lawsuit that's being filed against you. And then you have the sheriff's department or a private process server go out and serve a copy on the other side.
Yeah, yes, sir. We have the San Antonio Police Department trying to serve her. I think it was
Right.
both times that we were supposed
And
to
let me
have
ask the clerk's office, has citation gone out?
as far as
I'm talking to the clerk's office.
my bad. I'm sorry.
Judge, they had a notice of hearing to show cause that was signed and went out, but we do not have a return of service.
And was there a capias on that?
I'm sorry, I'm having trouble
Was there a
hearing you.
capias issued with that?
There was not a KPS with that.
All right. All right, sir. I can't have a hearing on something like this without service. I don't know that I could have a hearing if the other side showed up with an attorney, even if you had just that notice served on them. I want to suggest to you, if at all possible, this may not be the sort of thing that, I mean, you do not have to have an attorney, but this, if you simply cannot find this individual, you can get an order. If you file the paperwork correctly, basically for the law enforcement just to go and pick the children up immediately. You can get a writ of attachment for the children.
We had one of those, but they said that we didn't need a file.
Okay, well,
I'm sorry, that we had to have a judge sign it.
yes.
But,
Yes, sir. But what I'm saying is, as far as doing it yourself, trying to get a writ of attachment and things like that, and trying to get ex parte, which means just one party's in front of the court, temporary orders and temporary restraining orders, that's not a particularly easy thing to do. If you go to texaslawhelp.org, they may have forms that you can use for some of that, which makes it easier than it used to be. But this is, I use the comparison, there's changing your oil at one end of do-it-yourself, and then there's rebuilding your own transmission. What you're looking at needing to do if you can't get service on her is, it's not rebuilding your own transmission, but it's probably halfway between there and just, changing the oil on a vehicle, to use a comparison. So you're going to have, I can't be your attorney, but you're going to have to get her served, and it's going to have to be with the proper documentation and things. But you can try to, with an attorney, or if you get the proper forms filled out, to also just get an order to have the children picked up. And if you're able to file the paperwork to authorize the judge to do that, then whenever they find her, they could go ahead and just grab get the children. Now, the other thing I want to ask you is it the police department or the Bexar County Sheriff's Office?
County Sheriff, I'm sorry.
Okay, that's better, because I was going to say there's a first time for everything, but I've never seen a capias or a citation served by a police officer unless they're off duty and working as a process.
Oh, no, I
All right,
apologize.
so I'm not asking you to apologize, sir. I understand that you're not familiar with all that, but I just want to let you know why I can't take any action today.
Even though they missed the whole year of school and.
Sir, I'm not saying that there's not remedies that you have, but to use the analogy where you're wanting to, replace the carburetor in a car, you got to go buy a new carburetor or a rebuilt carburetor and get your gaskets and tubes and whatever. And if you don't have that, then you can't do it. You've got to go in and get the application, if that's what you're going to do, to ask for, writ of possession to have the children taken into custody by law enforcement and turned back over to you. If you can get that and get it filed correctly, then a judge can look at your affidavits, and if the judge decides that they're sufficient, then they could grant that relief. But until you get all that filed, the judge can't do anything. We don't have a system where you just go in court and talk to the judge and the judge orders things. You've got to have motions filed in district court to authorize the judge to take action. Okay.
All right, would I be able to reschedule?
Yes, sir. I'm just going to put reset on request. Yes, sir. You can, whenever you can get this done, I would urge you to try and find an attorney who can help. But if you can't afford that, and I understand how that goes, then at a minimum, try to go to texaslawhelp.org or somewhere like that and see if you're not able to discover paperwork that addresses the situation that you have.
No, I appreciate it. I'll go and do that.
All right. Good luck, sir. Give me just a moment here.
Do I enter?
Yes, sir. You're excused. Thank you.
Do I have to tell the date or?
You're breaking up.
Do I have to give them a call to set another date, or would they?
Yes, sir. But you're going to need to. I would get the paperwork first, because there's no sense trying to get a date set and having it put on a docket just for you not to have the paperwork filled out in time. So I would make sure you have your paperwork ready to file. And then when you've got it ready to file, then check with the coordinator's office and see what dates are available.
All right. Thank you.
Yes, sir. Okay, let me get the Arenas judgment signed. All right, and I've just posted the arena's judgment to the district clerk. Let me look at the Torres case. Okay, in the matter of the marriage of Segura, are both sides ready?
Yes, sir.
All right, will each of you raise your right hands? To each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
All right, and right. Ms. Segura, you are the petitioner. Prior to the time this lawsuit was filed, had you been a resident of Karnes County for 90 days and of Texas for 6 months?
Yes, sir.
And you're married to David Segura Jr.?
Yes, sir.
All right. Has the marriage between the two of you become undermined due to a discord or conflict of personalities?
Yes, sir.
Is there any likelihood the two of you are going to reconcile and live together again as husband and wife?
No, sir.
Okay, when did the two of you marry?
September 23rd, 1995.
Right, and how many children have been born to you since that date?
4 children, 3 are adult children, and 1 is a minor.
And are any of the adult children disabled or otherwise unable to support themselves?
No, sir.
And for any of your children, have the two of you ever been to court with the Attorney General's office or otherwise on a child support case?
No, sir.
And do you believe that the proposed orders you have for your youngest child are in that child's best interest?
Yes, sir.
All right. Give me a chance. Let me look at the child support part. All right, and right, and there's insurance available through your work?
Through mine, sir,
Yes.
I am actually providing medical, dental, and vision for my child.
Okay. Okay, and then I need to discuss with both of you the fact that the law in Texas presumes that everything a married person owns is community property. Okay, it's not a matter of whose name is on the piece of property. It's not a matter of whether the two of you have a dispute over it. It's a matter of if you're married and you get divorced and the divorce decree doesn't either say that it's community property and it's being divided up and one of the spouses is going to get it, or it doesn't say it's not community property, it's separate property because, for instance, you owned it before the marriage or you inherited it during the marriage, then the law presumes that the judge forgot to divide the community property of the two spouses and that they still own it together even though they're divorced. And years or decades from now, your ex-spouse's creditors can come back and claim that they're entitled to part of a piece of property. So if there's anything that's valuable enough that there might ever be a lawsuit over it one day, even if it's not y'all doing it, but creditors of somebody doing it, then it needs to spell out in the divorce decree who gets that property. So I see one explorer being given to Mr. Segura and a piece of house or land in Karn City to the wife and a Volkswagen. Is that all there is that is valuable enough? There might be an issue over one day.
Yes or no, that's everything.
Okay. And you say it's 304 Bushell?
West Bushell Avenue, yes, sir.
West Bushell, okay.
And it's
And
three,
is that-
I apologize, sir. It's three city properties is what it is.
Okay. And were they purchased during the marriage?
Yes, sir.
Okay. All right, you also have a Volkswagen. Now, did either of you receive any retirement other than Social Security? Or are you eligible for any retirement if you vested and earned anything while you're working?
I work for the school system, sir, so they automatically are taken out for retirement.
Okay, and how about you, sir? Do you have any retirement other than Social Security?
No, sir, I don't at this moment. No, sir.
Okay, now, do either side have any objection to me checking the box that says the husband's awarded 100% of any retirement he may have? Because what I've seen happen in the past is somebody worked for Walmart for 3 months 20 years ago, and they've got 2 shares of Walmart stock in a profit sharing plan still. And if it's not divided up in the divorce decree, they can't get it back out without getting their ex-spouse's consent.
No,
So-
sir, I have no objection.
so-
I'm not
okay,
requesting anything of it, any of his savings or anything.
Okay. All right. And you're going to use November 28th of 2020 as the date that each of you is responsible for their own debts.
Yes, sir.
Okay. And I may have already asked you this, ma'am, but are you expecting a child at this time?
No, sir.
Okay. All right, sir. I'll give you a chance to testify in just a moment, but right now, do you have any questions for your wife?
Can you repeat that, please? Sorry.
You'll have a chance to testify in just a moment, but right now, do you have any questions for your wife?
No, the only thing is my concern is, well, we did talk about the property and stuff like that. I know they're requesting probably other things, as a father and stuff like that for child support and stuff like that. But I know there's a royalties involved with this, and I don't see none of that. So I just want to make sure that we get everything included in this as well as property wise.
All right, sir, I'm not sure what you mean by that. Let me just say that there's two ways you can proceed. You can have a trial on how your property is going to be split up, and that trial may be over everything. It may be over just a few issues, or you can have an agreement. And so, do you all have an agreement on how it's going to be split up or not?
No, sir. I've been trying to talk to her about that to see what's going to happen on that. But like I said, it's there's things in there that are probably not been documented as far as property and royalties and stuff like that. It's just I understand that I've got responsibilities that I need to do, but I just want to make sure everything is clear, that we get everything else on top of it.
All right, sir. And again, I don't know what that means. I mean, it's clear to me in the divorce decree, it would be better if there was a better legal description, but it's clear to me in the divorce decree that your wife is getting all the real estate and all the oil royalty. So that's very clear.
Yes,
So-
sir. I just like I said, I just want.
Is that your agreement or not?
That. I'm sorry.
Is that your agreement or not?
Well, the agreement wasn't on that. It's like I said, she's getting.
Okay, so what I'm
everything-
going to do is I'm going to open up what's called a breakout room. And breakout rooms are little electronic rooms that the parties can go to. There's whoever I put in the breakout room is in the breakout room. No one else is. I'll give you all an opportunity to discuss this and see if you can come up with some sort of agreement today. If not, then we can either later on put on whatever evidence you need to put on, and we can have the trial right now. Or if necessary, it could be reset for a brief period of time for you to be able to have that breakout room later. So I'm going to assign both of you to breakout room number 3. Let's see, that's Karn Civil and okay, JESST. All right. You should have received a little blue pop-up that you can click on with the mouse that or your phone that allows you to join the breakout room. And if you come to an agreement, go ahead and exit out. If I get to the end of the other case that I have and you're still not back, then I'll probably go and speak with you.
I'm sorry. Is there any way that I can request another individual in that?
Who's that?
I don't know. Somebody on y'all's party?
No, ma'am. No. Okay. Again, this is electronic. There's no face-to-face physical confrontation. I know that there is a protective order on file.
Yes,
here.
sir. Okay.
So
All
I'm
righty.
gonna
Thank
ask
you,
y'all,
sir.
I mean, if I'll tell both sides, you're here to try and work that out so you can get this done. I mean, how much oil royalty are we talking about right now?
There's not.
Well, it can vary, sir, because next month it could be $4,000. It could be $200. It varies depending on the prices of how things work. It fluctuates. So it could be $50. It just depends. And like I said, I want to make sure
Okay,
that
all right. So I'll let y'all discuss that and see if you can come up with some kind of an agreement. And how many more school years does your youngest child have?
She's only in 4th grade.
Okay, all right. Okay, and I'm just throwing something, the sort of thing you might consider out is that half of the royalty would be, until she ages out, that maybe half the royalty could be credited against child support or something like that. So if it does turn out to be a huge amount of money, then part of that would be credited against child support, but that's just the sort of thing you might look at. So again, I'm going to ask both of you to join the breakout room, and I'll take announcements from the other case.
Okay, sir. Thank you.
All right.
Thank you.
All right, Katie Allen, what sort of case is this?
Your Honor, so my client's Katie Allen Investments used to own the Cnty Country Inn.
Okay.
There in Kennedy. They filed an insurance claim back in 2019. The insurance company refused to pay. Now there's new ownership for the property. So that's in a nutshell what the case. We've got two motions that are in front of you. We've got a special exceptions that Ms. McClintock from my office wrote. She's one of our junior associates. So if you don't mind, I'd like to give her an opportunity to argue her motion. And then underwriters also filed a motion for entry onto the private property of a third party. And I've got just a few points to address on that afterwards, if you don't mind, Your Honor.
And is the third party here?
They are not, Your Honor.
No, Your Honor, but they've consented to the inspection.
All right, so let me see if I can pull up the special exceptions. And all right, let's come back at 10 o'clock. We'll be in recess till 10 o'clock. I have access to these, it looks like. I'm going to go ahead and download all of them and look at them. And then we'll get started back up at 10 o'clock.
Thank you, Your Honor.
Thank you, Your Honor.
The Zoom room, the chat room.
I'm not sure, I don't hear nothing, so I'm not sure.
Don't, so you're back then. You're
Yeah,
back
because-
to your,
yeah,
so
because she
she's
want-
on recess.
Yeah, I'm going to be a few more minutes. Okay, it took longer than I thought, but I've read the motions and replies. Give me just a second, my pen is going dry. And we'll start out with the special exceptions.
Yes, Your Honor. Julie, you want to go start?
Yes. Good morning, Your Honor. My name is Julie
And actually,
McClintock.
there's Mr. Adler. You're ready, sir?
Yes, Your Honor.
Right. Go ahead, ma'am.
Okay, sorry. Good morning, Your Honor. My name is Julie McClintock. I am one of the associates representing Katie Allen regarding the special exceptions filing. If I could just give you a little bit of background. So Katie Allen purchased an insurance policy from underwriters, which specifically included additional coverage for collapse. Beginning sometime after February of 2019, some rooms at the Cnty Country Inn began having issues with sudden collapse, specifically when individuals were walking on the flooring, it collapsed under the weight of them. Underwriters inspected the property in June of 2019, and they viewed the collapsed flooring, but they refused to pay for the loss or honor the claims from Katie Allen. Katie Allen continuously insisted that their policy included coverage for collapse, but underwriters, again, still refused to cover the claim. Eventually, underwriters came back and said that the issue with the claim was that the collapse was not abrupt enough, even though people were falling through the flooring. By the end of 2019, over half of the rooms at the Cnty Country Inn were unrentable due to collapse in the flooring. And so Katie Allen was eventually forced to sell the property, which they sold at a significant loss because it was uninsurable due to the collapse. And they didn't have the money to fix the damage themselves, since underwriters would not pay the proceeds from the policy. So as you're aware, Texas follows a fair notice standard for pleading, which means that the pleading needs to state in concise and clear language what is being pled and just the nature and the basic issues of the controversy and the testimony that will be relevant. Texas courts allow special exceptions to be pled in order to compel clarification when pleadings are not sufficiently specific. And the Texas Supreme Court has allowed special exceptions to apply to affirmative defenses, which is why we're here today. What we're requesting, Your Honor, is that underwriters filed 17 affirmative defenses, and we are asking them to replead 2 of those 17 affirmative defenses, which, if you would like, Your Honor, I can share my screen to share with you the 2 affirmative defenses.
I've got it pulled up. Go ahead.
Okay. So specifically, the first one that we are asking for underwriters to replead is paragraph 9 that refers to an ordinance or a law, and that Katie Allen is in non-compliance with an ordinance or law. However, nowhere in their original answer do they specify any type of ordinance or law, or even how Katie Allen is not in compliance of said ordinance or law. So what we're asking is for them to give us additional facts just to help us pinpoint what potential ordinance or law they can be referring to, because there's so many ordinances or laws that are out there. The second issue is paragraph 15, which deals with there being a bona fide or legitimate dispute excluding Katie Allen from recovery under potentially good faith and fair dealing. But again, there are no facts to support this claim. Instead, this terminology is very vague. It doesn't really allow us to identify the specific issues. And I know that opposing counsel in their reply said that we needed to look at the prior 14 affirmative defenses, but even then, we still can't pinpoint exactly what legitimate disputes they're referencing. So as I mentioned, what we're asking, Your Honor, is for them just to replead these two to give us some sort of facts as required under the law to allow us to understand and kind of decipher what they're referencing. And then if they won't replead them, that you would strike these two affirmative defenses.
Okay, and your response?
Yes, Your Honor. Well, first, I'd like to just push back a little bit on the factual background they're representing to the court. Nobody represented to underwriters during the claim adjustment that people were walking through the floor. You'll see later on when we talk about the motion for entry of property that the contemporaneous adjuster reports don't say anything about that, and in fact say that the insured's representatives didn't know the cause of the damage. So I don't think that's accurate, Your Honor. And also, the scope of the damage was actually quite limited. They reported a claim for a hole in one room, not throughout the property. So they investigated it and determined it wasn't covered. So that's as far as the background is concerned. As far as the special exception, Your Honor, as opposing counsel acknowledges, it's a fair notice standard. That means you have to be able to generally assess what the defense is about. With respect to the first defense, the ordinance or law defense, that defense explains what ordinance or law might apply. It's an exclusion in the policy, and it says that to the extent you are seeking increased costs to comply with an ordinance or law governing the construction, then those costs are excluded. In that defense, I quoted plaintiff's petition. I quoted paragraph 11 of their petition that talks about what the engineer concluded was the cause of the flooring issues. The engineers concluded there was insufficient ventilation in the crawl spaces that caused, increased humidity, and it wasn't compliant with an ordinance or law. Opposing counsel knows what the engineer said. They quote it. They talk about the engineering report in their petition, and in fact, they attach it to their response to the motion for entry of property. So the source of the ordinance or law is one, it governs ventilation of crawl spaces. Two, it's something that by the way I pled it would give them fair notice of where I was coming from, because I was quoting their allegations in their petition concerning the engineer report. And three, if they just looked at the engineer report, which they have, they would see that it's the International Residential Code section R408.1. I mean, it's cited literally in an exhibit to their other motion. So they knew which ordinance or law I was referring to. But regardless, Your Honor, the fair notice standard is just to give them notice of where I'm coming from. It doesn't get into evidentiary matters. My defense is they're seeking property damage that they claim is covered under the policy. I say, to the extent they're seeking such and such costs to comply with ordinance or law, that part's excluded. I don't know what cost they're seeking. That's on them. I can only defend myself based on the same level of pleading standards that they have. If they told me we're not seeking to comply with an ordinance or law, then I can say, okay, well then I guess I don't need to plead that defense. But this is the fair notice standard. It's parity. You say it one way, you plead in a certain way. It's in general ways just to give me fair notice, and I plead a defense just to give you notice of what I intend to defend myself with. If discovery is what would help us identify whether or not plaintiff is actually seeking to recover those increased costs, or whether an ordinance or law actually applies. So I don't think the fair notice I think the fair notice standard supports the way I pled that defense. With respect to the second defense that they're challenging, which is the bona fide legitimate dispute, this is a common law defense, Your Honor, from extra contractual claims. It applies to the common law duty of good faith and fair dealing that an insurer has, and to statutory claims. They're the functional equivalent. I said that there is a bona fide legitimate dispute, which is clearly about coverage. And in my response to their special exceptions, I explained that we asserted 14 affirmative defenses, showing that it wasn't reasonably clear that the claim was covered. It wasn't clear when the loss occurred. They're not entitled to loss of business income. They didn't purchase that coverage. They didn't repair the property. The ordinance or law might apply. It might be excluded by fungus or rot. It might be excluded by wear and tear. It might be excluded by repeated seepage of water, et cetera, et cetera, et cetera. I cited many exclusions and many provisions of the policy that would limit or wholly exclude coverage or not allow it to fall within the scope of the policy. That shows that there's a bona fide legitimate dispute over coverage. If it was clear, I wouldn't have 15 affirmative defenses to the claim. So I think, and frankly, Your Honor, in a special exception, you have to say with particularity what exactly you think is deficient in the pleading. You have to say, you didn't cite this element of your defense. You failed to explain such and such. They didn't really do that. They just said that paragraph doesn't say what the facts are without looking at the pleadings as a whole, which is what the fair notice standard is. So I think with respect to both special exceptions, they should be overruled.
Ms. McClintock?
Regarding the first special exception, the ordinance or law one, again, going back to what opposing counsel said, where he keeps referencing the engineer's notes and the vague reference of ventilation of crawl spaces and the lack of it. If this is referencing a building code, then I don't think it's unreasonable for the affirmative defense to mention a building code, which even that, this is the first time that I'm almost positive the international code that he mentioned is just a vague code that might not even apply to our situation here. And he references also that there are certain damages that we're claiming that might apply, but all of this comes directly from the policy, and the policy even includes collapse coverage, even if there is an issue with the construction of the property. Regarding the second claim, with paragraph 15 and us being expected to look back at all the prior affirmative defenses, he still really never addresses what the bona fide dispute is, even though he mentions it could be rot or it could be damage or it could be this or that. There is nothing that is clear cut and that allows us to really see what he's referencing. And for that matter, both of these, as I mentioned, Your Honor, all we're asking is for them to replead. The fair notice standard does require some sort of facts. We're not asking for them to give us every single detail of what they're going to be arguing, but we would like some sort of fact to allow us to understand what is going to be referenced. Even next week, we have a deposition with their corporate representative. And if we're not able to understand what the basis of some of their affirmative defenses, then that doesn't allow us also to even prepare for that deposition next week, because we can't pinpoint or even get a general idea of what it is that they are pleading.
All right, and the question I have written down here to ask is contention deposition. And has that been, there's been a corporate rep noticed? Are contentions part of what's been noticed, or?
I am not sure about that, Your Honor. I don't know if Justin can speak to that.
No, I mean, more it's about the claim process and then kind of the specific decisions, Your Honor.
Okay, and have there been any contention interrogatories sent? Because here's what I'm looking at. I think the standard for special exception is pretty high, but I also think that the plaintiff is entitled to more information. But should that be done through special exception, or should that be done through contention interrogatories, or just asking the corporate rep, what is the corporation's contention? Because I think that the special exception rules, they're still there and they're still usable, but that they predate the ability to send contention interrogatories and or take contention depositions to corporate reps.
Your Honor, if I may, they already served discovery on us and we've already responded to it. I actually served discovery on them. Their responses they're due next week. So they've already taken discovery of me and they had their opportunity to investigate. But like I said before, I hasten to mention it. With respect to the ordinance or law, there's a specific provision in that engineer's report that they quote from in their petition that I am referencing in my defense. So it just the fair notice standard just requires to alert them, oh, he's using the engineer's report in his defense to say that to cure the ventilation issue, that's a, you know, that an ordinance or law might apply to that. If they look at the engineering report, which they clearly have, it's 2018 International Residential Code, section R408.1 through R408.3. That is the ordinance or law that may apply if they seek those costs for that damage. And so it gave them enough notice to go look at the report they had and quote it from in their petition. So I just don't think that's a reasonable argument, Your Honor.
All right, and let me ask also, the way I read your special exception, it looked more like you were pleading a special exception, which I've seen as a private attorney or an attorney come up with regard to flood rules where you have a piece of property can burn down or partially be damaged, but if it's damaged more than X amount, then you have to bring it up to code. And if you're in a floodplain, or that may be extraordinarily expensive. And then the insurance policy will often just say, well, we owe you the damages for the fire. And if it's going to cost 5 times that amount to actually fix the place, because now you're going to have to bring it up to code, we're not going to cover that. And it looked like your exception was not saying that the damage was done because there was an ordinance, but that if it's going to be more expensive to fix it, to bring it up to code or something.
That's exactly what the defense is, Your Honor.
All right. Okay, I'm going to deny both of the special exceptions, but I'll ask the attorneys to work together, and if we need to have a consideration of allowing additional discovery just to get contentions answered, to clarify if there's anything else, because I don't know what codes have been adopted in Karn City, and I don't know now if there's statewide rules. The last time I checked, there were not, but I keep getting surprised by things the legislature passed 4 or 5 sessions ago that changed what I thought the law was. So
Your Honor, could we get
the motions? But I think, yeah, the plaintiff is entitled to more information. I just don't know that special exceptions in this day and age are the way to get that.
Your Honor, could we get an additional 5 interrogatories then, just to address that? We've used 20 so far. Even 4 additional just to get us to 25.
All right, I'll give both sides additional 5.
Thank you, Your Honor.
And who's going to prepare that order?
I can do that, Your Honor.
Okay. All right. And then, Mr. Adler, you're going to argue the motion for entry?
That's right, Your Honor. Okay, so Your Honor, this is the Rule 196 motion. If you're trying to seek entry on a non-party's property, you have to file a motion, not just a request, serve it on the non-party. We did that, and the standard for allowing a motion for entry on property is it has to be seeking relevant information. There has to be good cause for the motion, which generally means it can't be discovered through any other way. We think, Your Honor, that clearly that the inspection seeks relevant information. The entire case concerns this motel in Cnty and the claimed property damage to it. But there are 2 components to that. Opposing counsel is almost entirely focusing on, the damage to the property itself, but they're kind of leaving out the whole part where they're claiming a loss of $1.7 million when they sold the property after the adjustment was completed. So we need to inspect the property, not to perform a coverage assessment, but to defend ourselves against the claimed damages. The property was sold last year, March 2020. We don't know exactly what the condition of the property is. There's been some telephone calls with the property owner who has said he's repaired the property. We don't know the extent of that, but even if it's completely repaired, the requested inspection seeks relevant information, which is 1, what's the value of the property? What's the value in its repaired state? What's the value? What would its value have been in an unrepaired state? What was the value at the time of the sale? So whether it's repaired or not, the inspection seeks relevant information. In fact, they're specifically seeking damages based on the condition of the property in March 2020 after we inspected the property. So we wouldn't have known what the condition of the property was at the time of the sale. They allege we bought the property in 2013 for $2 million. We sold it at a loss in 2020 of a loss of $1.7 million. So they're using the condition of the property after our inspection was completed in 2019 to establish their damages. We're entitled to defend that allegation, defend those damages, and look at the property and see what it was. They're also getting into the damage to the property itself. The scope of the claim damages is much different than what was claimed when we adjusted the claim. We went out, opposing counsel has attached reports, and they reflect that there are holes in floors in 2 rooms at the motel, 112 and 113. Everything else was sagging, sloping floors, cracking floors, which isn't within the scope of this alleged collapse coverage. The policy covers actual collapse under very specific, narrow conditions, not like property being in danger of collapse or having structural integrity issues. So when we looked at the property, there were 2 holes in the property. Now, in their petition, they claim there was holes throughout the property, throughout. That's in their petition. So we are entitled to investigate beyond what was told to us as the damage at that time, because they've changed the story. They flipped the script, and we're entitled to look at everything they claim is their covered damages now in this lawsuit. So, I think, Your Honor, it's certainly relevant. We certainly couldn't obtain it through another means because most of these damages are things that appeared to have occurred after we inspected, and the property owner has consented to the inspection. So there's really no concern over, the parameters for this inspection. Typically, in these cases, when there's the real argument between the sides about, whether it should be allowed or not, it's talking about where the inspector is trying to do some destructive testing or some serious disruptive activity. And so then there's a serious balancing of the equities. This is not the case, Your Honor. The person actually told me, the property owner told me I could inspect today if I'd like. So he has no issues with it, and there's no reason not to allow the inspection. And last, I'll just address a couple other arguments that they raised. They said that plaintiff's counsel would like to attend the inspection. I don't know what the purpose of that is, Your Honor. Generally, counsel always agree with each other to try and collaborate and work together to allow discovery to move forward. But they specifically are arguing that the inspection would not yield any relevant evidence. And it doesn't appear, they don't say anything about they'd like to inspect themselves. They'd like to have their experts inspect. They don't say anything about that. They just say it's categorically irrelevant. So I don't understand the purpose of them attending other than to just babysit, supervise, look over the shoulder of my consultants and see how they're doing things in a property they no longer own and have no interest in. So I don't understand the purpose of them attending. There is no conference requirement for this because, again, the party that requested the motion, the discovery, and the person who's responding to it are agreed, and the other party who's objecting has no interest in inspecting. There is no discovery dispute between the requesting and the responding party, so I don't think there's any conference requirement. But nevertheless, even though the parties consented to the inspection, it's important that the court sign an order because it would give clarity to me, my consultants, the property owner, as to what the parameters are. The rules require a showing of good cause and that the order reflect what the conditions and parameters are for the inspection. I'd much rather the court review the proposed order, the detailed order I submitted, and say which parts of it you think are reasonable, which are unreasonable, if it's all reasonable. So that way, if the property owner has any issue, I could say, well, the court considered these issues and has decided to rule. The property owner has the proposed order, he has the motion, he has the notice of hearing. He could have attended. I sent him the Zoom instructions. He chose not to because he doesn't have any issue with it. So I believe the court should just grant the motion.
Okay. Response?
Your Honor, to just briefly on kind of the facts, they try to make it out like there's only 2 holes. We've got testimony of one guy in particular that fell to the floor in 5 rooms and then testified probably to about 13 or 14 rooms that had evidence of collapsed flooring So I think that's a little bit of a misrepresentation. He might not like that testimony, but it exists. My big issue on this inspection, Your Honor.
Okay, but was that,
I'm sorry?
is that what was disclosed on the claim to the insurance company, that there were that many holes, or?
No.
So the initial claim was they were having problems with holes in the floors, and they sent a photograph as an example of the holes that they were experiencing in the floors. They came out and inspected and actually took several photographs of other rooms other than 12 and 13 that were showing cracked tubs and other evidence of collapse in the flooring. The claim was continued to be pursued for almost a year, with us trying to get them to understand that because they were trying to put it into a faulty construction category. And we kept sending them letters saying, and at some point we were involved specifically to say, hey, this isn't a faulty construction. Your collapse coverage covers this property and these damages, regardless of whether there's faulty construction or not. And so we continued kind of a letter writing campaign, if you will. And then eventually they just said, we don't care if it's collapsed, it's not abrupt enough. And there's testimony in the record from Derek Mapes, the former maintenance guy, that he told the adjuster that he fell through the floor in room 112. And I think it's worth noting, they never paid any claim, even for the holes that they observed during their inspections. But that's kind of despite the point or whatever for this inspection. I don't personally have an issue with them having an agreed inspection with the property owners. I can't really get in the way of that. I have a problem with the order that they're asking for, Your Honor, because I think that they took advantage of an unrepresented party here. And I can put the email up that he attached to his motion. But he says, and I'll quote it here. He said, my preference is that you agree to allow the inspection to go forward at a time that is convenient for you, rather than the court having to order you to allow the inspection. And so he offered, hey, if you'll agree to do this, I'm not going to go seek an order, after he had filed this motion. So no, he's not here to say whether he wants to or not. But the motion, in underwriter's motion, they're asking for basically unfettered access to the property, the interior, the exterior, the crawl spaces, the area underneath the flooring. This is the Cnty Country Inn is an active business. They've got guests in some of those rooms that have their own right of privacy. If Mr. Patel, the new owner of the property, wants to let him come look, I can't get in the way of that. But I do think that there is not good cause for the court to enter an order to mandate this inspection. And that's more my issue. And if the court is inclined to enter an order that mandates an inspection, then I probably need to have someone there present to make sure that they're not fabricating evidence or something of that sort, just to monitor what's going on. And I can't be there that day because I have back surgery the day before.
Okay.
Your Honor, if I may,
Go ahead.
I attended this testimony. All of this this is all subsequent alleged floor damage. They showed us 2 rooms. Again, they attached to their motion, their response to this motion, the adjuster report and the engineer report. Those are the 2 people that went out to inspect the property when the claim was reported. Both reports show a hole in 112, a hole in 113. If there were holes in 513 rooms, they should have showed it to them. But even if, again, this person who testified, who has serious credibility issues, but that's neither here nor there, he claimed that these continued to happen. He continued to step through floors. So it all happened after we inspected the property. Yet another reason why we should be allowed to inspect. And no one told underwriters that someone stepped through the floor. If you look at those reports, they say, we don't know what the cause of the damage is. We spoke to this fellow, Mapes, who he's talking about, and he said, I don't know the cause of the damage. If he stepped through the floor, he should have said, I stepped through the floor. But so we didn't have anything in our file to suggest that there was a collapse coverage issue. But again, that's neither here nor there. The point is, it's certainly relevant. We did not take advantage of anyone in respect to this inspection. We told him that our preference is that he agrees, so that we don't have an argument and a hostile person who's resisting our inspection, and we have to force him and have a constable show up or whatever. We wanted to do it by agreement, but nevertheless, as he knows, as Mr. Ratley knows, the court has to kind of weigh in on the parameters. I tried, I spoke to this person, but he's not an attorney, and that's why we need the court to issue an order. the property owner isn't competent necessarily to weigh the equities of the parameters of the inspection. The court certainly is. And all the things that we asked for in terms of the parameters are not that invasive, aren't destructive, no testing really. No testing at all. And is short. I think it'll take, I've said that the court should allow it for 4 hours. I think it'll take less than that. The whole issue, the reason why we need to look at every room and look in the crawl spaces is because that was the cause of the damage. And because they're claiming that it's throughout the property, unfortunately, we can't limit it to certain rooms because they have taken the scope of the damage and blown it up to grasp every area of the property. Their claim property damage in their petition is they've got a quote to repair the property for $512,000. That quote is for every single building in the property. So then I have to look at every building, even though they didn't show it to us, they didn't tell us about it. Now they're claiming it. So I have to look at it because I have to defend myself from the claim damages. So Your Honor, I don't think the scope is unreasonable. Mr. Patel, the owner, he had an opportunity to review it. I sent him the proposed order. I sent him the motion. He could have said, can you make this less restrictive? He didn't. He could have attended. I gave him the Zoom instructions. He didn't. And if the court thinks that it's a little bit beyond or needs a slight adjustment, I gave the court a detailed order where the court could change it to accommodate that. I don't think it's an issue. If you want, the court can make it shorter. I mean, it's entirely up to the court, but I think it's certainly relevant. I certainly can't get this information any other way. They insured the plaintiff doesn't own the property anymore. So they don't know what the condition of the property is now. They're just speculating based on a telephone call they had with the property owner. The only way I can get this information is taking the inspection. That's why these inspections are so important, and that's why they can go up on mandamus. It's not because it's just a general discovery request. It goes to the center of the case. If I can't get the inspection, how am I supposed to defend a $1.7 million loss on the sale argument based on a sale that occurred after I completed the adjustment? There's no way I could defend the claim unless I have a real estate appraiser go to the property and appraise the property, which is something that wouldn't happen in an insurance adjustment. So I just, Your Honor, it's necessary.
Right.
Your Honor.
Yes, sir.
If I can. My problem, I mean, and maybe it's something that we just need to reschedule this to have Mr. Patel be able to attend the hearing, because the email that he sent in support of the consent of the current property owner says that he wouldn't seek an order for if he got an agreement. And I can put it up on the screen if that helps.
Please do.
Go ahead.
Can you see my screen, Your Honor?
No.
How about now, Your Honor?
Yes.
Okay. So this is the section. It says, my preference is that you agree to allow the inspection to go forward at a time that's convenient for you, rather than have the court order you to allow an inspection, right? So he sent this, so he didn't confer with the property owner at all until after he filed this motion. And I could think, at least reading this, that he's trying to say, hey, I'm not going to go after this order if you'll just agree. And that would, convince him not to even show up to a hearing. That's where I have a problem with entering an order. And then there's guest rooms, but it's not my property. And if the owner is willing to let him just show up, then he can show up and do his inspection as they've agreed. It just doesn't take an order from the court to compel that. It's like asking the court to compel discovery when someone's already agreed to answer it.
It requires good cause, Your Honor. It's something, my preference
All right.
is that he
I'm
doesn't.
going to allow I'll sign an order for the inspection. I'm going to exclude from that any occupied residential quarter. So I don't think they're going to be very full in the oil business in Cnty right now. I may be wrong. And if there's people there that don't care if you come in and look, that's fine. I again may be wrong, but I would expect that this is not some bespoke place where every room is different dimensions. It says you want to be able to measure, but I would expect there's a limited number if there's more than one room sizes, and that Right. So who does the plaintiff need to have there? Does it have to be you, sir? Or, I mean, does it even need to be an attorney?
Well, I mean, I guess the question would be is if Mr. Adler's going to be there or anyone from his office, then I think I need to be there. If he's just sending an engineer or an expert, we can send an engineer or an expert. But I think that we need to kind of have a similar person to monitor.
Okay.
I'm
How
not
long are you
sure.
gonna deal with back surgery?
What's that?
I'm asking, I mean, so I have surgery on the 23rd. I will be out of the office for a week and a half before I can travel just down to the office. If we can do this mid-July, then there's not a problem. If that's unworkable, then I can send an expert, but I would prefer there not be another attorney there if I can't be there.
And are you gonna be able to go to Cnty and look in crawl spaces in July?
I guess we'll see, Your Honor.
Mr. Adler?
My goal is not to delay this. I just need to be able to attend.
Your Honor, if allowing it to go forward, if I don't have to, I'd like to attend, Your Honor, to make sure that I have the order with me and so that the property owner isn't confused about the parameters in the inspection. I question why Mr. Ratley needs to attend if he thinks it's categorically irrelevant and it's just to supervise me to quote unquote fabricate evidence. I think that's a very quite the accusation. I'm just going to inspect the property. This might take 2 hours. I have consultants. You know, I'm investigating the claim. I want discovery. They don't think it's discoverable. So I don't know why they need to attend. But if somebody needs to attend from his office, let him send one of the many attorneys at his office. He has a large office. Ms. McClintock is sitting here on the call. Have someone else go and attend the inspection. This is going to be a non-event. It's going to be very nice. It's going to take a few hours and it'll be over. There, you know, we're just taking pictures and looking at a property that to appraise it for real estate appraisal and estimating damages issues.
Your Honor, if it was only about appraisal, I mean, that's something that's routinely done with a photograph from the street. I mean, it doesn't take looking at crawl spaces to figure out an appraisal.
Not for testimony in a trial.
Okay. Right, and how large is your firm, Mr. Ratley? I mean, your Houston office?
We're in the Houston office, Your Honor. I'm not sure, we're probably 45, 50 attorneys. Ms. McClintock is a new associate that's recently started with us. She's the only other one that's on this case with me. This is her very first hearing.
Okay. All right. I'll order it for, what was it, June the 21st? What day? I mean,
I think 24, Your Honor. 24 was the date of the property owner. It's okay with.
Okay, I'll put 24.
Including occupied rooms, correct, Your Honor?
If there's people there and they don't care if it goes in, I don't care, but I'm not ordering that anybody have access to occupied rooms. And if you want to check, Mr. Adler, if that's going to be an issue, because they're full, then we can come back and address that. Also, I don't know how big this place is. I know with lots of little motels, the owner lives on staff, on site, and they have living quarters there. And I'm not saying that you have to be able to, if he doesn't want it, have access to Mr. Patel's residential living quarters if he and his family live there or something.
Okay.
Mr. Patel lives in California, Your Honor.
Okay, well, or a manager or whoever. All right, so he really doesn't care because he's in California. Okay. All right then, so that was the 24th?
Yes, Your Honor.
And I'll add plus representatives of the firm and their agents. All right, give me a moment and I will post that ask the district clerk to file it, let y'all have your copies of it. Anything else before I do that?
No, Your Honor.
All right, and Mr. Ratley, you're getting me an order? Or
Yeah, 5 additional interrogatory requests and the denial of the special exceptions. Correct, Your Honor?
Yes. Okay. All right. Give me a minute. I'll make these changes to the order and I'll file it.
Thank you, Your Honor.
Your Honor, is it easier if I file the proposed order, or would you rather me drop it in the chat? I've got
If you have it in, drop it in chat would be the quickest.
I can do that real quick. Okay, Your Honor, it's in the chat. Oh, I messed up on the last line. Looks like.
I just posted the entry order to everyone. I'm going to ask the district clerk's office to file a copy.
Your Honor,
It's,
I'm actually, plaintiff's attorneys are with Munch Hart, and I'm with Walker Welker.
I meant defense attorney. Okay, I'm sorry. Well, no.
I think you meant plaintiff's attorneys and Munch Hart were allowed to inspect.
I meant the defense. Oh, okay. Let me do that.
So have you decided if you're keeping Zoom around after coronavirus?
I wish.
Okay, Munched Heart, Kopf, and Har, PC.
Yes, Your Honor.
Okay, I'm sorry. Let me. Yeah. I'm not sure how we're going to do it, but yes. What we're going to try to get worked out is probably on weeks where, at least where I have the same county twice. I'm going to try and have one of those be a Zoom docket, and we're going to experiment. We're not sure exactly how we're going to do it, but to have somehow just an uncontested docket for Zoom cases. So that all of the uncontested hearings we won't have to worry with. And what I'm going to tell people is civil, criminal, I don't care. I'm not going to hear arguments about notice. I'm not going to, I don't care if the defendant shows up. If the state gets mad because they don't show up and they were supposed to, they can withdraw their offer, but I'm not going to call any nice eyes for criminal defendants who don't show up. It'll be an agreed docket. If it's agreed, we'll do it. If not, set it some other time and just see how that'll work. All
It's
right,
interesting to see how a lot of courts are deciding what technology they're going to kind of keep out of this versus not.
Well, and I think that it'll give people a lot more. I know it'll give people a lot more options trying to hire attorneys in some of the rural areas if the attorney at least has the hope that, well, if we don't wind up with a contested final hearing, I can represent them in this divorce or this whatever. But if they know for a certain that they're going to have to drive to Cotulla just to prove up a divorce and be there for 5 minutes, you're going to have to spend a lot of money to hire somebody from Austin or wherever to Houston to come down. All right, so. Okay, and I just posted the order on special exceptions also.
Okay.
Thank you, Your Honor.
I'll make sure we get it out of the chat before close out here.
Y'all are excused. Have a good afternoon.
Thank you.
Thank you, Your Honor.
Okay, in the matter of the marriage of Segura,
Yes, sir.
Yes, sir. Yes, sir.
where do we stand right now?
We couldn't come to an agreement with the property.
Okay, so do you want to proceed
Yes.
and have a contested? Okay. All right, then you're the petitioner, ma'am. Let me ask you to describe in a little better detail what this property is and how much income it's been producing and what you want to do with it. And then I will allow Mr. Segura to ask questions of you, and then I will allow him to testify about what, since he's the respondent, if he agrees that's what it's worth and what he wants to do with it. So go ahead, ma'am.
Yes, sir. It is basically 3 city properties. There's nothing on the property.
Okay, and what does that mean? 3 city properties?
They're just properties. We used to own a home that was next to it, and we no longer own the home and those properties. So it's just the properties itself. There's no building on it. There is nothing on the property itself. So any value to it is only going to be the property and what they value it at the city. But there's no buildings, nothing like that to it.
Okay, and how big are they?
I want to say they're 25 by 75. If I'm not correct, David, he would be the one to tell you.
They are 25 by 120 feet per lot, and they sit right next to each other, side by side. So you're looking at 75 feet by 120 or so, 125 feet.
Okay, and whose name are they on in the appraisal district's records?
Both of ours.
All right, and that's on Bushell, you said?
Yes, sir. They used to be under a 312 Bushell, but then they had to change the address to 304 because the 312 went with the house.
Okay, and do the parties have any objection to my going to the appraisal district and seeing how much the appraisal district values them?
Not at all, sir.
No,
Mr.
sir.
Okay, let me click on this.
I also, sir, was able to pull up the actual direct deposits of what we receive, where I can, I think if all I have to do is hit the share screen, I can share that with you.
All right, well, this is 0.202 acres. And the appraisal district values it at $4,200. Go ahead, ma'am.
Can you see that, sir?
Yes.
Okay, so trying to take this other screen off of here. So I have gone, this is actually the highest that we've received within the last year. The remainder of it, that's what that is.
See, that's why I said honor, if you don't mind.
No, sir, you'll have a chance both to ask questions of your wife and to testify on your own behalf in a moment. All right, ma'am, and how long have you been receiving interest? I mean, a royalty income?
Oh, honestly, I don't even know. 5 or 6 years, maybe? Oh, here you go. 2014.
Okay, and it was considerably more when it first began.
Yes, sir, absolutely. But in the last year, do you mind if I scroll back up?
Go ahead.
From 2019, January, I will start slowing down.
Okay, thank you.
Yes, sir.
All right. And what are you proposing happen with this property?
Myself, sir?
Yes.
I would just like to keep it. It's the only thing that we have. As far as property goes, we have 4 children, 3 adult children. I have one son our son, that would like to put a RV on it. But really that's about it. I mean, I don't want to sell it. I don't want to get rid of it. That's it. I don't have really plans to build or anything at this point. But I don't want to sell it because, I mean, we did work hard to be able to have it. And I'd like for it to stay within our children.
All right, Mr. Segura, are you still there?
Yes, sir, I'm here.
All right,
I'm listening.
this is not a chance for you to testify. You'll have a chance to testify in a moment. What questions do you have for your wife right now?
As far as what, Your Honor?
It's your divorce, sir. You're having a contested trial over basically just the division of this 1/5 of an acre there in Karn City or in Cnty, the Karn City. So what
Yes.
questions do you have for her about that?
I did try. We did
All
try
right, yes,
to.
sir. I'll give you a chance to testify in a moment. Right now, I'm asking you, do you have any questions for your wife?
Well, no, sir. I mean, it's just that, like I told her,
Okay, all right. So now I'll give you a chance to testify. What do you want me to be thinking about?
Same thing she wants is just to be able to keep the, property for the kids and not to have to do away with it if not needed to.
Okay, and what do you mean not to have to do away with it?
Like sell it or anything like that, I mean, it is ours, like we did work hard for it. And I want to be able to have something for them if that's the case. I mean, if it's possible. I'm not looking to sell anything, but if we can't come to an agreement, then.
All right, and sir, again, you're past coming to an agreement, so. All right. And sir, I'd have to say that's more argument than are there any facts that you think your wife got wrong? Or are there other facts you want me to be thinking about?
I just, I mean, really, I don't got no questions for her. I mean, because we're not gonna get it, to that. So, but as far as question wise, no, sir. I think the property should stay where it's at. I mean,
Well, sir, the property is going to stay where it's at. What you're having a trial about is who's going to own it. So are you asking that you that you receive it and not your wife?
Well, I mean, it is under both of our names, but like I said, I'm not trying to sell it like she doesn't want to sell it. So I want to keep it where it's at. If all possible between the both of us.
So does that mean that you're asking that you continue to own it together?
Yes, sir. For the kids.
Okay, and again, you understand, I cannot compel you to set up some kind of family trust or something.
Yes, sir.
Having to do with land. All I can do is divide your assets, and then once the divorce is final, then the two of you will have to go on about your business.
Yes, sir. Well, if it has to go split right down the middle, then yes, then we have to do that.
Well, no, sir, I'm supposed to make a fair division of the property, and I am pretty certain that you couldn't even, I'm not sure you could create a lot that small in this day and age in Karn City. I'm very certain that you're not going to be able to subdivide it. I would expect there are city rules and ordinances about subdividing property that's not going to allow you to subdivide it. Because
Yes,
there's
sir.
certain minimum
Yes, sir, I understand that. Like I said, like she said, it's 3 lots. And I understand 3 lots at 25 feet by 120 it's not a lot.
All right. Okay. Give me a moment. All right, anything else from you, ma'am?
Regarding the lots, no, sir.
Okay, and y'all are in agreement as to everything else?
Yes, I believe so. Well, I have, the vehicle, I have is that what we're referring to? I'm sorry, I don't want to go off subject.
Well, I didn't hear that there was a dispute that each of you is going to keep your own vehicles. He gets the
Oh, okay.
Explorer. You
Yes,
get-
no, that's the only thing. That was the only thing that we couldn't come to an agreement with.
Okay. All right, so give me a moment. All right. And before we go further, let me ask, ma'am, I saw that you had checked that you wanted a modified visitation plan, and I could see from the number of pages that there was an attachment. But you don't really have a visitation or possession plan attached. You have a list of things you'd like to see.
Correct, sir. The only thing would be because of the protective order.
All right, no, but let me tell you what I'm getting at.
Oh, okay. I'm sorry, sir.
The final decree of divorce is an order the judge signs that orders certain things to happen. If you want to enforce visitation or possession orders, there has to be a clear order. The court, the order always says it's whatever the parties agree. Y'all can do what you agree to do. And if you don't agree, then X, Y, and Z is what happens. If what the judge orders is that you'd like to see something happen, if you try to enforce it, well, the judge didn't order for something to happen. The judge just signed something that you had your attachment that said, well, you'd like for certain things to happen. And that doesn't protect you, and it doesn't protect Mr. Segura, because it doesn't tell him when he has the right to have access to the child. It doesn't tell him that possession is supervised, is not supervised. It's just nebulous. So do you want an opportunity to, I mean, I'm going to say, I'm not going to, do you want an opportunity to submit something else and see if you and he can agree to that, or what do you want to do?
I apologize. I think that I had checked where it stated that he would have like every other weekend and 1 week out of the one week out of the 1 day out of the week, and then alternating holidays.
Okay,
But
I don't see any of that.
Okay.
I mean, it's a standard possession plan, but what you said was that you had a modified possession plan and that was attached.
No, I think, I apologize. I think I misunderstood the wording. I do want it standard, because I don't want to change anything. I just only want there to be a location where we can meet. That was all I wanted.
Okay, well, we're just about finished here, and Mr. Segura, do you have an objection to that?
No, sir. I mean, we can meet to pick her up, but like I said, I mean, I didn't, as well as you said, I never saw nothing as far as.
Okay, and again, that's fine. All right, ma'am, do you have access to, where did you get this? TexasLawHelp.org, or where did you?
I did, yes, sir. Yes, sir, I did.
Okay, I'm gonna, in just a moment, let Ms. Cavazos go, the court reporter, but I will stay on. I'll let the court coordinator's office go. I'm gonna ask you to just go over to TexasLawHelp.org or wherever it is and get a standard possession order. We can put in the language that says where they're gonna switch possession. What would be an appropriate place? Lots of times we will use.
My mom's house, the 403 West Calvert.
Okay, now I'm going to very strongly suggest that you make it a public place, and that way you don't have the emotional attached context of, you know, that's my former son-in-law showing up. He's showing up and saying, that's my former mother-in-law.
Okay.
That's why I would suggest Dairy Queen.
Dairy Queen would be fine. Yes, sir.
All right, so if you will get one of that and fill it out, and then do you have are you on a computer?
I'm on a laptop right now.
Okay, you should be able to just fill that out in a PDF format and post it in chat. You would just need to go to chat and then click on to everyone, and then it'll have a little box to the right that says file. And you can go to wherever you have your standard possession order saved and post that, and I can add it to the divorce decree. I'll keep this going. What I am going to order on the division of the property is that I will award the surface to the wife, Ms. Segura. I will order that the mineral estate be divided equally between the two of you, meaning that you're going to have to get a copy of the divorce decree is probably a certified copy, but I'll let them tell you if they need it certified, because they may be able to access it online to whoever does the division orders that you get your payment through. And that way, the two of you will receive, whether it's a little or a lot, you'll continue to own the minerals jointly with 2/10 of an acre in the city. I'm not worried about leasing so much, and that they're not going to be able to go out and, put any kind of oil field location on that or something. But and just so in case y'all don't know, in Texas, you can separate the right to explore for oil and gas and lignite and uranium and all that. You can separate that from the surface, and different people can own it. So ma'am, you will own 100% of the surface, and the two of you will equally own the mineral interest.
Okay, sir. Thank you.
Okay. All right. So I'll release, ask the clerk's office to stay online. I'll release Ms. Cavazos and Ms. Riley, and I will keep my speakers on. If you will just speak up whenever you get that, and I'll come back and look at it and attach it to the divorce decree.
Okay.
All right, Judge, we have another Zoom hearing tomorrow. I'll see you then.
What is that?
I believe we have another Zoom.
Yes, but what is it? Do you know?
Oh.
I don't remember.
It was a reset. Let's see.
Special setting cards.
That's how I see.
18-3-84. Okay, I'll look it up.
De novo hearing. Hicks versus Melvin.
Okay, I'll look at that.
Okay.
Thank you.
All right, thanks.
I'm trying to get a PDF file on here. I don't know.
You already have the file?
That's
Or
what
you have
I'm-
to change it?
That's what I'm trying to do. I need to change it, but I can't figure out how to do it.
All right, ma'am, did you download it as a PDF or as some kind of like a Microsoft Word file or something?
I downloaded it as a PDF.
You ought to be able to just fill it in and as long as you can save the changes.
Let me take a look and see. I'm sorry, I didn't realize I was on video here. I mean, on. Okay.
In honor, and this is, what she's filling out, what was, gonna, be in effect for what, sir?
All right, Mr. Segura, it's the possession order for possession and access to your daughter. And I'll let you have a chance to look at it. And there's some elections you need to make in there. By that, I mean, you can either, pick the child up at say 6 o'clock on Friday evening, or if they're in school, you can elect to pick them up at 6 o'clock, rather pick them up directly from school. So there's some elections that you're going to need to make, and I'll let you look at that.
Sir, is this the 6F possession of access to the children?
I don't know what it is. It ought to say standard possession order or something like that.
Okay. It's just not allowing me. I don't know what I'm doing incorrect.
All right, ma'am, it's not allowing you to do what?
To access it, to be able to do changes. I've downloaded, I've saved it as a PDF, and it won't enable changes.
Okay, can you print the document?
Yes.
Can you print it to a PDF? By that, I mean, instead of printing it to your printer, just print it to a PDF and you'll make another PDF copy. Sometimes you have to do that.
Okay.
When PDFs are messed up.
Okay, I think I might have gotten it now. county residents, marriage, grounds of divorce, children, jurisdiction over children. Okay, conservatorship, custody of the children. Is that what I'm doing?
And I don't have the forms in front of me, but yes, that sounds like that's probably right. And there ought to be a bunch of little boxes you check that say, 6 p.m. Friday to 6 p.m. Sunday, or from the time the child is released from school until when the child returns to school Monday.
Okay, I sent something and I'm not sure if I did it correctly.
All right, let me see. All right, Mr. Segura,
Yes, sir.
I just posted the Segura standard possession order. I deleted all the other pages. You need to download that to the computer there in the clerk's office and then try to open it up. They ought to have Adobe Reader or something on there. So just click on it and hit download.
What am I clicking on? I don't see anything.
Okay, go to chat. And if you don't see a box at the bottom that says chat, there ought to be a box with, or there ought to be 3 dots that say more. And then go and see if there's not something there that says chat. You see it? Were you able to find chat, sir? Okay, it looks like Denise is coming to help.
Okay, Judge, he's reviewing it. Do
Okay.
you want, if you want, we can print it and have him sign it as well? And then I
Okay,
can
and he doesn't have to sign it if you just click the boxes. If usually just on on Reader, there's a way that you can insert text and just to make an X to click on something. And are you looking that over now, sir? Mr. Segura? All right, Mr. Segura, are you looking that over now? Can you hear me, sir?
Oh, okay.
Okay.
Can you hear me now, sir?
Yes.
Yes, sir. I was looking at the paperwork,
Okay.
page 6 of 6. So can I go from there? How do I get?
What do you want to do?
I don't, well, I already looked at all
Okay.
this right here, so.
So do
Right,
you
and
want
did
to
you
talk to him?
check whatever boxes you want to check, or did you decide you don't need to
I
check
didn't,
boxes?
I'm supposed to check these boxes?
Yes, sir. There should be
I'm
just
the-
6 pages.
Yeah,
Well, cause see, when I hit it a while ago, it didn't do anything.
All right, and you may have to go to insert text or make comments and just like type an X in there to check something.
Let's go down. Is there anywhere that you need to put an X so I can help you put it, show you where to put it?
Well, because it looks like it's,
You had a question on page 6?
well, no, because I was reading, because see, I didn't, this looks like, well, it says Thursday, weekends and stuff, but it just, from 6 p.m. to
Yeah, standard.
standard, so it just looks all the same to me,
Okay.
So.
All right, you don't have to check stuff, sir. You just get the regular, the non-extended if you don't check, or that's how it used to be. I don't know.
I don't have to mark it in it?
If, no, you don't have to, is what he's telling you.
Okay.
But there's something.
But
that
just to pick up, just to have her on.
Okay, Judge, I'm here with him, but he doesn't need to, if, I heard you tell him he doesn't need to sign, click anything if he doesn't want to, correct?
Let me go and look. Yeah, that used to be, it used to say you got the standard if you didn't, the regular if you didn't choose the lesser one, or the extended one.
Oh, okay.
So it's just, we agree to,
No, it doesn't say that now. It says check one. So if you'll look at, there's boxes you need to check.
Yeah, you'll have to
Again,
read and you'll have to
Well, see,
check.
that's what I was looking at, because when I hit it, it didn't do anything.
Okay, so tell me where you want to hit it and I can show you. And I can try to help you.
Okay, well, we gotta go. I
Okay,
think
this is the
we-
first
Yes,
page.
ma'am.
Okay, so tell me what page you want to go to. Yes, he does want to mark some stuff, but he needs help with it.
Okay.
Okay. Thank you.
Let's go over and let me see what
What's that,
we
ma'am?
can do. Okay, what do you want to mark?
Like right here, well, it says Thursdays, so what is that? Because it has weekends and weekends extended by the holiday, but then you got Thursday, can you kind of explain it to me why it does that? Or-
No, sir, the clerk can't give you advice. So you can just make your selections is all you can do.
We can't, since
No.
we're not attorneys, we
Yeah.
can't advise.
No,
you.
I'm asking, why does it have Thursday? Because you have the weekends, but why does it have Thursday like this?
Because that's how
I'm
the
not asking-
legislature, sir, I'm telling you not to ask questions to the district clerk. They can't answer it because the Texas legislature says if the parents can agree, they do whatever they want. And if they can't agree, here's the standard possession order and you follow it.
mark it.
You want to mark something?
Oh, that's what.
Okay, so
I'm
this
gonna-
is where you're gonna go in and you're gonna select it. So you want to mark, let's see. Sorry.
Yeah, no, you're fine.
Let's see. And then you're going to see where this has a box right here for text. Then you go to the page you want to, the area, and you go over it and you're gonna mark an X over the area you want. So right now it's set up for you to mark.
Okay.
So let you mark.
I'm just trying to.
Just click the box, click it right over it.
Right there.
Okay, make an X. Did it let you do an X? Okay, let's hit delete. Let's try that again. Box selected.
Can I just skip all that or?
And then an
Or
X,
just
try an
like that?
X, try an X. You see the X?
Mm,
Here, let's make it capital. See, it's over there. Okay. And it is ready for you on the next, anywhere else you want to make a mark.
Okay.
Okay,
Okay.
it'll stay set.
Yeah, okay. Okay.
Okay, so, so are you done marking?
I think so.
Okay, Judge, can you hear us?
Yes.
Okay, he said he's done marking.
All right, if you'll just save that and then post it in chat, I will attach it to the divorce decree and sign it.
Okay,
And thank you so much for helping him.
no problem. Okay, so we're going, this one is the one with the one.
Mhm.
I identified it with the SPO1 just so that it's different on my desktop.
That's a good idea.
So then we're gonna do this. And we're gonna look for. Okay,
All right, give me just a moment. All right, I just posted the signed decree to everyone. That's not a file stamped copy, Mr. and Ms. Segura. That's just the signed copy. You have to get the file stamped copy from the clerk. And there's also a document called a BVS, or Bureau of Vital Statistics sheet, Ms. Segura, that has to be filled out and filed with the district clerk. It's just a fill in the blank form that it lets Austin know about this divorce. Have you completed one of those?
I honestly couldn't tell you. It doesn't sound familiar. I know when I went and filed everything, they said everything was complete.
Well, that's for the filing. This is due after the decree's been signed.
Okay.
I know TexasLawHelp.org will have copies of that if you need it.
Okay. Yes, sir. Absolutely. I will look on there. And you said just sign it and go and drop it off just like I did anything else?
That's fine. Yes, ma'am.
Okay.
And they probably have copies there. I don't want to speak for them, but I think they probably have copies there.
And can you
We
tell
do
me,
have
I
copies.
apologize. Oh, I'm sorry.
We do
ma'am,
have copies of those on file here if you want.
Yes, ma'am. So when I go in there, you'll know what I'll be needing?
Yes.
Okay, wonderful. Thank you so much.
Okay, then I will find out. A petitioner had been a resident of Karnes County for 90 days in Texas for 6 months before the lawsuit was filed. 60 days have passed since it was filed. The petitioner has appeared and announced ready. Marriage between the parties has become undermined due to a discord or conflict of personalities, and there's no likelihood of reconciliation. There was one child born during the marriage that hasn't reached 18 years of age, and no other children have been born or adopted who haven't reached 18 years of age. And I find that the proposed orders concerning that child are in the child's best interest, and I will approve them. And I will find that the proposed division of the marital property is just, fair, and equitable. And I'll find that the division that I made of the lots in Karn City and the royalty interest of those lots is fair and equitable also. And I will pronounce the divorce in open court. I wish you good luck, ma'am.
Sir, I have one more question.
Yes.
We didn't discuss child support. Is that something else? That's something different?
Okay, it said $500 a month in the divorce decree.
Oh, okay. Okay. All right. Thank you very much.